Alex here with part 142 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed, it cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series, to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into my ex's attorney's opposition to my motion seeking leave of the court to open discovery in a very limited way. I guess you could say my mindset at the time was once again dismayed. They have shown their win at all costs mentality probably for the later third, I would say, of the My Docket series, and part of that strategy includes limiting as much information as possible. I know that I have lambasted the judge before about this particular issue, specifically the doublespeak as to how he wants as much information as possible so he can make the right decision, and yet when he's faced with these questions on me getting more information to him in the past, he has historically found ways to deny any kind of effort to get more information to him. So this is what happens when you have a judge who is making meta rulings. Please watch that video because it might seem like you're dealing with somebody who doesn't make any sense at all. But when you watch the video meta rulings, all of a sudden it'll start to click for you that they're not really paying attention to the facts or the evidence, that what they're paying attention to is what is the ruling going to make you do. And in this particular case, this is the judge who wants me to stop filing things. And so he thinks that the one way that he can get me to stop filing things is to constantly find reasons to rule against me. Inadvertently, by doing this, he's facilitating child abuse and neglect. But this isn't something that he can see, especially since he's stated in previous court orders that he feels the litigation process in and of itself is harming the child. In other words, the filing of papers to him is what's harming the child. He's not looking at the contents of those documents to read them to see exactly what the child is going through. He's just looking at the fact that a filing was entered and I was the one who filed it. Therefore, I must be the bad person. So at this point in time, to see my ex's attorney's opposition, I was worried that this may be an issue again where this judge would deny the relief that I was requesting. But at this point in time, as I mentioned, I think 2 videos ago when I talked about the filing of my motion to modify child custody, I was really angling for and preparing for an appeal anyway, which is why I still went ahead and filed that motion. So I hope I didn't kind of get around this or over this, but what I was trying to say with that gigantic paragraph statement is, yes, it's dismaying to see my ex's attorney trying to oppose me getting information in front of the court, but I planned for that all the way in advance, way back before I even filed that first motion. And so I anticipated not only this response from my ex's attorney, but also from the court. And even I'm not even really at that point yet. The court hasn't entered a ruling on this motion yet, on either of the 2 motions yet, but I'm already sort of planning for an order denying, because the documents that I've been filing have been preserving arguments, have been citing statutes and case law, and so I have been angling for and preparing for an appeal from the very beginning. So I hope, sometimes I really wonder if these videos are confusing for you guys. So far I'm getting good feedback from you, but I always worry that maybe I get too technical sometimes, or I get too much into the weeds. And anyway, I like to see your feedback down in the comments below with regards to these kinds of, I guess you could say, technical sort of analyses of not only what's going on, but what I predict is going to happen in the future. And guys, I've mentioned this before. One of the biggest, I guess you could say, ingredients to the recipe for success in litigation is anticipating not just your opponent's response, but what is the court going to do, and having sort of backup plans. And one of the best backup plans that you could have is an appeal. So this is, it's not really going to play out in the worst case scenario. First off, you already know that this judge is going to recuse himself in this case as well. You've seen a couple of videos back that the judge recused himself in the other case, the CV 13-01019 case, the civil writ case. And he does recuse himself in this case too, but this timeline isn't quite caught up to that other case. So when we do catch up to there, you'll see the order of recusal here. So that's the first sort of thing that wasn't planned for. I didn't expect him to recuse himself. The other thing is that he doesn't really rule on this motion anyway. He sends it to the Discovery Commissioner. And so that's going to be something that we can, at least that's what I think he does. We'll find out. I think at this point in time, I've covered my mindset well enough, and we should go straight into what my ex's attorney has filed. Here we have my ex's attorney's opposition to motion for leave of the court allowing limited discovery. Standard introductory paragraph, she introduces her client, indicates to the court that she's the one representing her, and states that she's filing the opposition to the motion that I filed seeking limited discovery. So first thing she asserts is that I have failed to establish good cause for the court to allow post-judgment discovery of the CPS information reports. Let's find out why. First paragraph, she says that I'm asking the court to allow me to issue subpoenas ducus tecums to CPS to produce 2 additional information reports. Let's see, the potential to reveal further abuse and neglect relevant to the court making a determination. I claim that I recently became aware of these information reports being made to CPS based on a conversation that I had with the child's teacher, who told me that she submitted a report herself. Let's see here. After learning about the one information report submitted by the teacher, I made a request to CPS to provide a case summary. In response, they sent me a letter which mentioned that the additional reports that I was requesting, a copy of the letter which I received from CPS is attached here too as Exhibit 1. So that must be a document that I already I'm sure I provided this already, so it's going to be an exhibit we don't even go over. In any event, opposition to my motion to modify child custody, which I filed February 25th, 2014, discusses the behavioral problems which the child was having at school, and the opposition further explains why the information forwarded to CPS did not constitute any abuse or neglect on the part of my ex, as to why CPS reached this conclusion. So guys, this opposition that she's referring to hasn't been filed yet, but I am 99% sure that that's actually the next document that she files. So we're going to be going through that opposition. For now, though, hang in there. Despite the finding that the information report which the teacher sent to CPS did not merit further investigation, I'm now asking the court for leave to discover 2 additional information reports which CPS similarly found as not meriting further investigation. The mere fact that the court is not bound by administrative decisions does not automatically mean that there is good cause for the court to allow. So she says that the mere fact that the court is not bound by administrative decisions does not automatically mean that there is good cause for the court to allow the requested post-judgment discovery of 2 additional information reports received. This statement is wrong. She's trying to confuse the court. I think she probably knows this. Sometimes I think she plays dumb. Sometimes I think she deliberately tells the court something that's not true as to how the law works. So what this is it's a principle. It's a res judicata principle. There are 2 species of res judicata. One is known as issue preclusion. One is known as claim preclusion, also known as collateral estoppel and also known as collateral estoppel and merger and bar, respectively. To know how these 2 res judicata principles work is one of the biggest keys to dealing with the family court system, because very often judges and attorneys will try to apply preclusive effect to determinations that are made by police departments and CPS agencies, which they can't do, except under rare circumstances. First off, claim preclusion is never going to apply, because neither the police department nor CPS will be subjecting this kind of complaint process to like a formal litigation process. There may be, I highly doubt it, there may be claim preclusive effects when they institute abuse and neglect proceedings, but again, I very highly doubt it. Issue preclusion has a much more likelihood of coming up, and even that doesn't automatically happen. You have to look at how issue preclusion works, and you have to satisfy all 4 elements before that matter is barred from the family court. It's very unlikely that either of these 2 species of res judicata will apply, but these attorneys don't know how it works, or they deliberately don't bring it up to the court, and the judges either same thing. Either they don't know how issue preclusion works, or they deliberately do know how it works and deliberately just try and find a way to toss a case. So they're committing legal error when they dismiss these claims. Unless issue preclusion or claim preclusion applies, these determinations will not bar you from bringing these issues before the family court system. This is reversible error. If this judge rules in the opposite direction, you can have that decision overturned on appeal. The Supreme Court of Nevada will overturn the decision on appeal because you can't block. Anytime you're trying to say, hey, my opponent can't bring this up because it's already been decided, you have to show how it fits into res judicata. You have to do it. And if you cannot do that, then you are wrong. So again, guys, if you are trying to bring an issue to the court and your opponent is saying you can't do that because it has already been litigated or decided by somebody else, they are trying to cite res judicata, and that is a big fat red flag for you to see if res judicata applies or not. So do your research. Don't just blindly believe them because it sounds believable. A lot of people will hear that argument and they'll say, hey, that sounds believable. CPS said it was unfounded. So of course I can't bring it up here. It sounds believable to the average person, but when you look at the legal doctrines, it actually doesn't work. And the Supreme Court explains why. There's different due process concerns, different statutes apply. Sometimes you're not even a party to that process. There's all sorts of issues that come up that actually show why you are not barred from bringing those issues to the court, even if CPS said something different. And so please do your research here. This is such a common area that people make this mistake. So I have 2 videos out on the topic. Number 1, issue preclusion, and number 2, claim preclusion. Those 2 videos will help you sort of get your head around how this works. So Max's attorney is trying to say that I don't have access to discovery just because the CPS agency made the determination. Sorry, hold on, let me look at this again. The mere fact that the court is not bound by the administrative decision does not automatically mean that there is good cause to... Well, okay, so in a way she's right. I still have to show that the information is relevant. So, I mean, ultimately she's going to reach a point where she's wrong, though. Let's check the next section here. It is clear from the letter that I received from CPS that 2 information reports that I want to discover are similar to the information. Actually, it's not clear. She's just saying that. And that none of the information reports warranted further investigation. She has to show that the information is irrelevant. So she's still trying to bind me to that CPS determination that there was no further investigation warranted. So she hasn't said anything new here. So in the first sentence, she says basically that I'm not entitled per se to discovery, which is true. But then in the next section, she doesn't bring up something outside of the boundaries of that final determination by CPS. Let's see if the next sentence actually does. In other words, none of the 3 reports, including the 2 which I seek to discover, meet the criteria warranting an investigation. So again, she's still stuck on the final determination made by CPS. That's not going to work. Except as otherwise provided by law. And then she goes into how the CPS agency applies the law. So all of this here is going to be discussed by the Discovery Commissioner, and he's going to explain to you guys why this attorney is wrong. So when we get to the actual determination by the Discovery Commissioner, we'll actually talk more about why this is a wrong-headed approach to trying to basically bar me from bringing this claim to the court. The post-judgment discovery stop at me constitutes a very heightened potential for abuse, which I acknowledge as the reason for the requirement that before a court grants post-judgment discovery, the applicant must show good cause, which is what I'm doing. Rule 16.21 states, unless the court otherwise orders that parties are privy. So she's actually just regurgitating the same arguments. Based upon the information report made by the teacher that did not pass the prima facie criteria to warrant... Why does she say prima facie? That's not used by CPS at all. So she's trying to mutate the CPS agency's process into a court process. She's trying to force it to fit into res judicata, but I don't see her cite res judicata or issue preclusion. So it's kind of like, I guess they call it gobbledygook. There's another thing, they call it word salad. She's bringing up a bunch of statements that kind of sound lawyery, but none of it actually applies to the law. So most of these arguments in this paragraph here, I'm going to deal with on reply. So when we get into my reply, we're going to talk a whole lot more about how I confront these arguments that this attorney is making. Next section here is before CPS reports are publicly disclosed, the court has the authority to examine the reports in camera. That's true. The law provides that. That's fine. If the court wants to do that, the court can do that. But again, remember what I talked about in the past with in-camera review. The court can only decide if the evidence is relevant or not. If the evidence is relevant, the court must turn it over. The court can't just decide to make a decision on it then and there. The court can say, this is relevant, turn it over to me, and then it gets brought up at trial in the presentation format. So I'm going to go ahead and move on to the next section. Conclusion, I failed to show good cause. This is a conclusory statement. So none of this is true, guys. One of the things that I was hoping is that by her asserting that just because issue preclusion doesn't apply, you aren't automatically entitled to discovery, which is a true statement. That's actually a true statement from her. One of the things I would hope is that she would follow that up with some kind of attack as to the relevancy of the evidence, but she doesn't do that. She spends the entire page and a half stating the same exact thing that she did at the very beginning of this opposition, which is, because of the decision made by CPS, I'm not entitled to the information. So, I mean, sometimes an attorney will say something that's true, and then they'll fail to back it up. So this is true. You can't just get information just because issue preclusion doesn't apply. You still have to follow all of the other rules of evidence, which is that the evidence is relevant and that it's likely to prove something in the case that's relevant to what you're trying to get. But unfortunately, in the remainder of this document, this attorney doesn't actually assert that in any way, shape, or form. She just continues to point at the determination made by CPS, which continues to bind her to the trap that I described earlier on, which is that issue preclusion does not apply in this case. We're going to talk about this a whole lot more when we get into my reply to opposition. I'm going to get pretty technical in that document. But for now, this attorney has failed to otherwise oppose with any kind of reasonable basis my access to that information. And I will get that order granting. So let's move on. We got a certificate of mailing under Rule 5. This is indicating that she mailed this to me. We got the motion opposition notice, which apparently indicates that she did not have to pay a filing fee. We have the exhibits, and this is an exhibit that we already went over. So again, as with my previous videos in the My Docket series, I don't go over the same document twice in the My Docket series, but you can go down into the description below, click on the link, download the document for yourself, and that way you can actually take a look at it for yourself. And if you see anything in there that you think I should have discussed, go ahead and mention it down in the comments below, and I will cover that. Going into the aftermath, I filed, actually I didn't file anything, so I incurred $0 in costs. My ex's attorney filed an opposition. That's a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, to prepare this opposition, she would have probably spent about an hour. I mean, there wasn't anything in there that was useful with respect to how the law works, but it was a substantial amount of detail that she went into, even though mainly she just kept repeating herself over and over again, trying to get the court to focus more on the disposition by CPS and less on the actual substance of those allegations and claims, which is a good tactic by the attorney. She is trying to induce the court into committing legal error on her side. She wants to win the case. But in any other... I mean, I don't see anything else in there to make it more than an hour's worth of work, and I just can't bring myself to say that it would take less than an hour, because she would still have to communicate with my ex, and she would still have to review the motion itself. So there is a lot of side work that goes into preparing this opposition. So I think an hour at the rate of $250 an hour is going to be reasonable in this case. It's going to cover my ex's attorney fees at $250. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.